Hi, and Happy New Year. I'm Dio, and welcome to Court Watch, where we talk about the importance of keeping eyes on the judicial system, advocate for vulnerable people targeted by this system, and explore the best ways to protect ourselves and each other while we work to abolish the system. I'm not a lawyer, and this is not legal advice. My experience and knowledge is most relevant to New York State, and variances may occur depending on the laws where you live. Today, I'm going to address a specific question I received from a friend, which speaks to both a very unique issue, but also has some ramifications that apply more broadly. So, a friend shared this scenario. Someone they know who has a disability and has what's called a payee has received two eviction notices from a landlord. I'm assuming this is based on the context. I'm assuming that it was related to non-payment of rent. So, for those who are not aware, a payee is a person or an agency that basically receives an individual's income and manages their finances for them. Typically, the payee is supposed to pay all of the bills and then give any remaining funds to the individual as the equivalent of like pocket money. This system is often employed when someone has a disability, and the idea is that their basic needs will be met by this third party payee. Now, there are many valid critiques of this system, and that's fair, but that's not what we're going to do a deep dive into in this video. But this does raise an important issue. When someone else is supposed to be responsible for paying your rent, what happens if they don't? Now, I will say that not being familiar with the details of this case, a few things are possible. For instance, the landlord might be lying, and I've watched this happen enough in court to know we can't rule it out. So the agency may in fact be paying, and the landlord may have brought a baseless case. That is always a possibility, but I don't know enough details to say. So I'm going to assume, for the sake of this video, that the agency either failed to pay or failed to pay the full amount. I've actually seen something similar in court with a slightly different scenario. What I witnessed involved an elderly gentleman who also happened to be disabled. Now, this gentleman did not have a payee in the same sense, but he did have Section 8, which was responsible for paying his landlord. So this was kind of being orchestrated behind the scenes out of his direct control. He was summoned to court because his rent increased with a new lease, and somehow Section 8 was not aware. In talking to this man in court, I learned that this is something somebody overheard us and shared that this is something that actually happens all the time. But from this individual, I learned that he is a widower and his deceased wife used to handle these matters for him when she was alive. In fact, when he got his eviction notice, he didn't understand the reason he was summoned to court. He thought he was brought to court for something totally unrelated. He shared the letter with me, and I read it to him. It stated he was being summoned to court for a whopping rent deficiency of less than $80. He was shocked as he assumed Section 8 was managing this, so clearly there was a miscommunication of some kind. Now, in this gentleman's case, when he was called up before the judge, he did not have a lawyer. But we had talked briefly before, and I gave him some non legal advice suggestions. One suggestion was that he ask for what's called a 14-day adjournment, basically asking the judge to give him 14 days so that he can seek a lawyer and get a little more information together. The other suggestion was to focus on the fact that he has Section 8. Fortunately, in this case, the judge gave him some time to contact Section 8 and get everything squared away, and he was not evicted. The judge did have him come back a month later so that they could review what updates had been made, what progress had been made, and his landlord's attorney confirmed that the payment was made, and so everything was going to be okay for this individual. But I want to highlight a few things that go on in court as it pertains to disability specifically. We can't make any assumptions as each individual is different, and even disabilities differ and manifest in different ways. So just because this person was able to successfully advocate for himself in this scenario, that doesn't mean everyone can do it and have the same outcome. And while it's become, thankfully, normalized to accommodate disabilities in different ways in many settings, this is seldom the case in court. Particularly in eviction cases, which have become such a mill that processes so many evictions in a day or in an hour, most cases are decided in a matter of minutes without a word from the tenant, who is usually not represented by a lawyer. So we can't assume a judge is going to take the time to assess the tenant's needs and make exceptions even when it's rational to do so. So the scenario I shared prompted a discussion between myself and this person's landlord's attorney later on. One thing to bear in mind, this person's landlord is the local public housing authority, an institution that houses numerous people with disabilities of all kinds. And you would think there would be mechanisms in place to prevent a situation in which an elderly man who uses a walker is forced to take a bus and appear in court on an icy January day. But there isn't. And when I talked to the lawyer about his thoughts on these cases that could easily be resolved with the slightest amount of case management, to my surprise, he agreed. I say to my surprise because the eviction pipeline has really no incentive to have less cases, and that includes lawyers. Most judges are hearing cases in a rapid fire style. They're not interested in context. They don't really care where someone's coming from or what they're dealing with. Most cases are very focused specifically on the letter of the law, and everything else is ignored. And although a few judges may be more conscious of these other factors, we can't take a gamble that this will happen just because someone either has a disability or has a third party payer or both. Now, let's talk about another situation that did not go as well for the tenant. Another local tenant was given a Section 8 voucher to move into an apartment, and she moved in. But after moving in, Section 8 changed their mind. Yes, for real, they changed their mind and they didn't release payment to the landlord. Now, there's a lot of background to this, and largely it had to do with the landlord keeping his units in such bad condition. So that, again, logically, his fault, not the tenant's fault. But here's how it played out in court. Although she had documentation of all of this, the landlord had documentation from Section 8, so he knew that Section 8 was involved. He was aware that she was not the primary payer. Still, he brought her to court and claimed wrongfully that she was a squatter. Now, again, despite all of the documentation of her involvement with Section 8 and even a new letter from Section 8 in which they were agreeing to pay, the judge still sided with the landlord. So, although logically we would think, hey, the tenant is not the person in control of paying the rent in this case, that has to count for something, don't count on it. Because really, it doesn't. The tenant is summoned to court. Their payee, Section 8, other institutions, they are not summoned to court. They don't go out of their way to advocate for the tenant or even get involved in any way unless a letter is sought by the tenant or their lawyer. So, all of this to say, there are a number of issues brought up by this scenario. One is how disabled people are treated in court, and there are a lot of issues with that, which will be a later video. But also, the basic question of what happens when a tenant is brought to court because someone else failed to make their rent payment. And unfortunately, the answer is unless the tenant or their attorney is relatively savvy about arguing for their rights in court, there's a chance it won't matter even though it was someone else's fault. We can't take for granted that the judge will care or even take it into consideration. And if that sounds cold, it is. And that's why we need eyes in the courts to show the judges their decisions are being watched and we are going to name names and hold them accountable. And speaking of naming names, the first scenario involved a decision by Judge Waite in Saratoga Springs, and the second involved Judge Sloat in Malta, New York. So, lastly, if we are watching court, if you are watching court and you interact with a person who is in a situation similar to one of these scenarios, remember to start by telling them you're not a lawyer and this is not legal advice, unless, of course, you are a lawyer. Encourage them to ask for a 14-day adjournment and seek legal counsel. If they can't find a lawyer, encourage them to focus on the facts of the case because that is what the judge will focus on. Encourage them to get any documentation related to their payee or Section 8 and to ask the court to make 2 copies and not give away originals. And finally, it's essential we not judge tenants. We don't know what someone's situation is. If you are someone who reads and responds to every letter you get in the mail, you may not understand what it's like to have difficulty understanding letters sent, especially from a court. They're written in legalese and often use language and terminology that can be confusing and intimidating. Thanks for watching, and don't forget to like and subscribe and keep an eye on the courts.